Thank you, Mr. Chairman, and thank you to each of our witnesses. It's been really a fascinating discussion. And Mr. Steyer, I do believe you're right that this is an important issue, that the time is now. In fact, I think this the issue of privacy, given the explosion of data and technologies with the power to collect a lot of data, are continuing to expand. This could be one of the defining issues of this decade as to how we deal with it, because with data comes power, and that power is based on data collected from us each individually. So we have to be leaning into this very heavily. So I agree with that. My first question, though, for you, Ms. Giuliani, is that as an example of some concerns that I have. There's a popular pregnancy tracking app, Ovia, that tracks medications, mood, bodily functions, and more, and even use it to track newborn medical information for women that use this app. You may be familiar with it. The app has come under scrutiny because it allows employers to actually pay to gain access to the details about their workers' personal lives. Your testimony, you were very clear, and others have mentioned about how federal law should limit purposes for which consumer data can be used. So my question, though, is what should be included in federal privacy standard to ensure that employers, in particular, cannot have access to their employees' medical information from an app such as Ovia?
I mean, I would say first that that is information that shouldn't be given to an employer absent the consent of the individual using the app. And they shouldn't be denied using it if they say, look, I don't want my employer to know that, but I would still like you to measure these things. So I think that those are sort of two sides of the same coin. And what I worry with apps like these is, again, these long privacy policies that individuals don't have time to read or understand, that effectively require them to sign away all these rights just to use a service.
Well, to follow up on that comment, in Ovia, they have a 6,000-word consent form. The company is granted, quote, a royalty-free, perpetual, and irrevocable license throughout the universe to utilize and exploit their de-identified personal information. The company is allowed to sell, lease, or lend aggregated personal information to third parties. This basically means that all of the information that is gathered, packaged, can be sold to whoever they want, whenever, as long as it doesn't meet their de-identified criteria. But how difficult is it for a company to re-identify someone if there is enough data about them? Let's say a smaller company that may only have one woman who is pregnant. Could you identify that person, probably even with de-identified data?
Yes, I mean, re-identification, I think, is becoming easier, and there are companies that are innovating around that. So, for example, there have been MIT studies that found that de-identified data could be re-identified 95% of the time with accuracy. So I think it's really important that when we talk about de-identified data, we're really clear on what that means and making sure that it is, in fact, de-identified.
Right, right. Mr. Polansky, example, if I go to the doctor and I get prescribed an allergy medicine, and then I put that information on an app that I have to keep track of the number of doses I have to take on medicine or whatever it may be. How do you envision a federal privacy law working with existing laws such as HIPAA to ensure that my medical information is indeed protected after I put it on my own app?
Yeah, this is increasingly going to be an important issue because patients are increasingly downloading their medical records, and there's obviously great value in people being able to see that data, maybe take it to a different doctor, analyze it themselves, but they may not appreciate that once they've downloaded it from their HIPAA-covered entity, that it is now in their hands, it's in their app. Legislation should recognize that there are sensitive categories of data that are going to be subject to much stricter and tougher controls. I may want to share that with another doctor. I may have a friend who's a doctor. I may want to show it to my spouse. And so I certainly should be able to share it, but it ought to be very clear and very practical, and I ought to be able to revoke that consent. It isn't likely to be covered by HIPAA, but we increasingly have data that is outside of the regulatory world where we need to make sure that the consent standard in any proposed legislation is indeed balanced.
Yeah, in March, it was reported that a data broker tried to sell the names, addresses, high schools, and hobbies of 1.2 million children. This was uncovered through the violation of Vermont's recently enacted law to regulate data brokers. Mr. Polansky, as you know, the Vermont law requires data brokers to register with the state annually and gives us some transparency as to who's actually out there, who's actually collecting all this information. Understanding that the law was just recently implemented, do you have an early assessment of the law, and should we look at that law in guiding some of our work at the federal level?
Yeah, I don't have enough information to know how it is playing out, but it's clear that people today have limited idea of the number of places their data goes when they're online or when they can transact, and providing a simpler way for them to get to those endpoints so that they don't got to go to multiple places, so they can say no once, or they can go to one place and effectively take their data out, I think is valuable. Frankly, I think it's valuable for companies too. The people who really don't want to be getting catalogs in the mail and don't want to be marketed to, it's costly to send some of that out, and I'd like to believe that at the end of the day, there's a win-win by giving people more control over what they receive from a whole range of third parties.
Thank you. Appreciate it.